Good morning, everyone. Welcome back. We're back in session. I know several of you. We've been trying to figure this out together for years. You all have been doing, or many of you have been in this every day for literally years. We really appreciate your help trying to guide us all through what I'll call the fog. So our panelists are Judge Richard Cousins, um, Simon O'Connell from the Contra Costa District Attorney's Office, Elizabeth Lashley Hayes from the Public Defender's Office in Los Angeles County, and Lisa Romo from the Office of the State Public Defender. Did I mispronounce anybody's name? Okay. And we're okay with time, Mr. O'Connell? Great. So I'm going to keep our original schedule, which we were going to go in that order, and start with you, Judge Cousins, if you don't mind. We for those of as our custom, we really hope everybody can keep their opening remarks to 5 minutes. And usually the most substantive and helpful part of the conversation is actually the conversation, the Q&A that we'll have after everybody's gone. So with that said, Judge Cousins, can you kick us off for 5 minutes?
Certainly, and it's my pleasure being here again. Thank you very much for having me, Michael.
Thank
Um,
you for coming.
it's been my job just to kind of track cases as they have come out. Once I took my initial shot at trying to interpret the RJA, now my role is shifting to kind of tracking cases and for some reason attorneys and judges listen to other judges who are actually deciding these things rather than me opining. So that's my focus, and I think actually a lot of the things that Tom touched on have been covered recently by cases, and I'll just quickly emphasize the important points. There's been a trickle of cases. I call it kind of a trickle. It's about a one a month have come out on the RJA. It's not as aggressive as some of the other more uh, aggressive laws, for example, like the accomplice liability, which has taken a lot of court time, a lot of appellate time. We're not seeing that yet. That's kind of interesting. I think the big issues are still out there, kind of floating like the iceberg, and we're going to be seeing them. But as we've seen, there's been some focus on what constitutes a violation under the A and B, the one and two categories, but nothing yet really on the statistical ones. I think those cases are out there. I sort of hear rumbles about them, but nothing has really come forward yet. But I think that's a thing to come. There have been procedure cases on the right to appeal, for example, for not having raised it in the trial court. I have to say the one opinion that did express that that is a waivable situation if you don't raise it as soon as you can is something that frankly appeals to me as a trial judge, and I think it appeals to the appellate courts because it does limit the issues on appeal because there is the overall overarching direction in the act that you are to bring it as soon as practicable, and that holding is consistent with that. We'll have to see if that plays out. Um, Obviously, there's been some instruction to judges about the preliminary showings necessary. I think the important message that the appellate courts are now getting out is that judges at these preliminary determinations shouldn't be doing weighing issues of credibility. That's something that, unless it's something absolutely refuted by the record, you're not to get into the issues of credibility. The discovery issues, I think, are very important and will take increasing amounts of time. As Tom indicated, there is this issue between two appellate divisions that talk about the standalone right to discovery or only in connection with a motion. The Supreme Court has granted review of both of those cases. So if the legislature doesn't act, then of course the Supreme Court will. So that's kind of an interesting problem. The issue of the remedy. And initially, I took the position that remedy was mandated from the list, and there's an appellate opinion that disagrees with that opinion and points out that the remedy is not mandatory. But if a remedy is granted, it has to be responsive to the issue. So that's going to be kind of an interesting thing to play out. And finally, there have been a couple of cases on lawyers and when they get involved. And we've seen issues where a lawyer himself is the subject of the challenge on the RJA, and also the issue of does the court have to follow the very formalized process? for appointment, or can you go outside of that in extreme circumstances? And there was a case dealing with that, which indicated that the rules are not so tight as they might be. And I'm sure all of you are aware that Rule 4.553 has now been adopted by the Supreme Court and the Judicial Council for appointment of counsel. So they're sharpening up that area. So I think it looks and it's a very high quality standard, which I think is a very good thing for everyone. So those are my opening comments, and be happy to respond to questions later. Thank you.
Thank you, Judge. And I should also promote, you have one of your infamous memos on the RJA, which I think is extraordinarily helpful. Among other things, it has a table of, well, extremely helpful. And anyway, I advise everybody to take a look at that. Mr. O'Connell from Contra Costa.
Hi, Michael. Thank you so much. Michael, you may or may not remember me. About 3.5 years ago, you actually came over with students from Stanford to present on a prosecutor-initiated resentencing case. Really expanded our horizon in the applicability of that. So thank you. And hopefully I can pay it forward today with everybody here.
I remember we sat in your conference room, and I think our client is out and doing very well. So thank you very much.
Absolutely. We're very proud of that as well. On to the topic of today. And Judge Cousins, thank you for outlining, as well as Tom, many of the issues regarding the RJA and its implementation. I have one starting point which I'll address, and I welcome many questions about all these areas. When you can open a knot with your hands, you don't need to pull with your teeth. And one area I believe we all have common ground in, and that's the public defenders and the prosecutors, is we can improve the efficiency and the clarity of the data discovery process. Much of the information necessary to assess these potential claims and disparities, and as prosecutors, I want to make sure that we are fairly and impartially dispersing justice and making corrections for past wrongs. We have no problem in my office of rectifying a wrong when we see it. Those disparities and that data is kept in a singular place, the courts, which have authority, which no one questions, as to the reliability, the accuracy, and completeness of that information. Unfortunately, as the RJA is currently constructed, the onus is on an individual petitioner to independently compile records through request to the prosecutor's office as the government to then piecemeal together various forms of information, whether that's the original charging document, whether that is the plea that was entered in the court, whether that was the sentence imposed by the judge, what records may be even in the California Department of Corrections. I think if we could resource our courts, and I emphasize resource because the RJA is an unfunded mandate, and while I believe in its wisdom and its aspirations in order to rectify racial disparity within our system, we have not empowered our public defender's offices or our prosecutors' offices with funding in order to then gather all of this material. And unfortunately, perfection in gathering that data has been the enemy of progress and resolution of these cases. I think we can decrease litigation delays in these RJA claims, which, as Tom referred to it the other day, are almost becoming now capital-like litigation in the amount of time and resources and cost that is impaired by them. And we can significantly improve the completeness and accuracy of records relied upon to evaluate RJA claims if we could get those from a single source, that being the court's data. And I know for Contra Costa County, we have robust data that is in our court files and court records in their digital case management system, but the courts have yet to be inclined to share that information as a sole source. I think the issues of remedy, forfeiture, harmless error, and all those other aspects which Tom outlined. I'm happy to speak on with more particularity from the questions that may come about from today. But I wanted to start with that, offering up sort of a different way of maybe how we can look at where data can come from in order to accelerate the litigation of these claims.
Thank you. That's certainly helpful. Miss Lashley Haynes from LA.
Yes, hi, thank you. Can you all hear me okay?
I can. And I should have started off by saying thank you all for coming. It's incredible service to us. Hopefully the state. We are certainly learning a lot every time. So thank you for taking time out of your day. And I also want to recognize that Priscilla Ochin is joined us. Welcome. And so with that said, Miss Lashley Haynes, if you could give us 5 good minutes.
Yes, thank you so much. And thank you all for having me here today. Just to situate sort of who I am in this space a little for you all. I am a deputy public defender in Los Angeles County, and I am the senior attorney in a Racial Justice Act unit that we have in our office. Our office was the first one to develop such unit, and I have been in that unit since essentially the passage of RJA. So in 2021, I began in this unit, and I've been exclusively litigating the Racial Justice Act from that time forward. I have been sort of on the forefront of monitoring various legal developments, legislative changes that have happened, and I've been involved in trainings throughout the state with everyone from defense practitioners to police agencies. I've asked to speak at a police conference. I've gone into San Quentin State Prison and spoken with clients in there about RJA, about bringing claims, and I've even spoken nationally about the California Racial Justice Act. I also developed and run a statewide group of public defender practitioners of RJA, and I've been doing that since around the same time frame I started gathering folks together around 2021. It includes representatives from 23 different public defense offices throughout the state in 20 different counties. So I say all that just to explain that I have a good sense of not just what I'm doing here in LA County, which, as Judge Espinosa mentioned earlier, LA County does make up a huge amount of the cases and, a third of our prison population. So we are dealing with many, many, many RJA claims, many, many asks for a look at cases for folks from prison. But I also have a fairly good sense on what's happening in other counties, other large counties and other small counties, the tiny little counties that are in the Central Valley, and the issues that they are struggling with as well. I often get the question of, have we seen any success in RJA? Or I hear claims that we haven't gotten very far. While I think we haven't gotten as far as we have wanted to in the last 4 years, I think that I personally have seen substantial progress, but I also see substantial challenges that we face with RJA. In the beginning, it was very difficult to try to figure out how to fashion a viable claim and how to bring a successful RJA claim. Where do we begin? What was the prima facie standard? What are the remedies? What actually constituted bias or animus? How do we get data? How do we prove the disparity? What is similarly situated? These are all the questions that we struggled with in the beginning. And unfortunately, as I revisit a lot of that, they are some of the questions that we are still struggling with today. Yet, I like to remind folks that in the beginning, a lot of us had challenges even bringing or winning a discovery motion or getting past prima facie. And now that is more common. And I have frequently won discovery motions, gotten past prima facie, gotten to evidentiary hearing. And in fact, I'm right in the middle of a data-based evidentiary hearing as we speak. So I think the thing is, I came into this with no illusions that the RJA would immediately see motions granted, bias and racism acknowledged, and a fast track to sort of a more equitable and bias-free legal system. Um, but I do remain hopeful that I do want to see more truth and more justice occurring in the courtroom when we are talking about RJA. Um, what what I am seeing, unfortunately, on a daily basis is sort of an effort to remain stagnant and remain where we were pre-RJA. I think that there is a denial about racism and a lack of common sense when we are discussing racism and bias in our legal system. And I see a major effort to uphold the status quo. Um, this is truly groundbreaking legislation, and it in the legislative history, they acknowledge so many truths about racism in our legal system and how the criminal justice system has been inextricably tied to racism and bias from the beginning. I believe it will just take steadfast and unwavering litigation of RJA to have its actual intended effect. Um, I'm not sure, as we have discussed many of the changes and the fixes that we need for RJA. I'm not 100% sure at this point what exactly they are. And specifically, when dealing with the penal code, how can we fix the penal code to further some more just outcomes with RJA? But I would agree with Mr. O'Connell that data is one of the major areas that I have been adamant about that we need improvements. What is happening in reality is the bar to make a database claim is higher and higher and higher and higher to the point that it is nearly virtually impossible to get anywhere on a database claim. Um, and I also, the reality is, it takes me full time, as many hours as I work in a day and a week to bring a database claim. It took nearly 2 years for us to work up a database claim for a variety of reasons, delay after delay after delay, new data, enhanced data, expert battles, and that is untenable for an average trial attorney who's not doing what I'm doing exclusively. Sorry, Michael, I saw you raising your hand. I will jump really quickly. Um, I think there needs to be massive increased training. I don't know if that's something the penal code can tackle, but there needs to be training for the bench, prosecutors, attorneys, everybody, for everything from historical racism and how that has impacted policing, the criminal justice system, juries, training on implicit bias, racialized trauma. Um, there definitely needs to be clarity on the remedies. Judges ask me all the time, and almost every single time I walk into court on an RJA, what are the remedies? What are you asking for? How does this work? What do you think the penal code says? And also, there are many aspects of the retroactive cases that need to be clarified. There is a lack of consistency that I'm seeing with the bench. I have cases that the judges summarily deny everything that they're getting on a retroactive case, judges that don't appoint counsel, all the way to judges that appoint us immediately on every case. So there's a complete lack of consistency, and I think there needs to be better direction on who gets a counsel and at what stage. What does that mean? The prima facie standard for retroactive cases needs some major clarifying, which I know that the courts are trying to do. And I think that's it. Oh, and funding. Again, Mr. O'Connell sort of indicated that, but there is a complete lack of funding and resources for everybody, for public defenders, indigent counsel, frankly, for the DAs, because I have a discovery motion where it was ordered by the judge and the DA's office, it took them 10 months to get anyone who is able to gather the discovery that was ordered. So there's resources that are needed across the board to make this statute become a reality and for people to start seeing some type of justice and relief to come from the RJA. Thank you.
Thank you. Like I said, I think that so many of us are on the same page. The challenge for us, obviously, we don't make laws. We can make some recommendations, is to try to find really specific ways that we can have the best impact possible. We know we're not going to solve racism, but we can try to do our small part. With that said, last but not least, is Lisa Romo from the OSPD. Hello again, Lisa. If you give us 5 minutes, and then we'll just jump into questions.
Thank you. I'd like to thank the committee and staff for inviting me here today to speak. I think we are at an inflection point with the RJA. In some early Court of Appeal opinions, we saw a recognition of the groundbreaking nature of the RJA, recognition of the legislature's intent to rid the criminal legal system of bias and animus, particularly including implicit bias, and a recognition that the legislature's intent was to move past legal doctrines and canons that prevent claims from racial discrimination from being raised. But lately, we have seen an increasing willingness of the appellate courts to erect obstacles to the resolution of RJA claims on the merits. We've seen the invocation of doctrines like forfeiture, invited error, ineffective assistance of counsel, all used to avoid merits determinations. And this is true even when the Attorney General has conceded the merits of an RJA violation and has expressly declined to raise a procedural bar. We're also at a critical point in the development of RJA law as to the application of harmless error. In an early case, Simmons, the Court of Appeal found that the legislature intended to make RJA violations remediable without any showing of actual harm in an individual case. The ruling in Simmons not only affirmed the legislative intent, but made sense because it's extremely difficult to show the impact of implicit bias in an individual case. Social scientists have established that implicit bias is real, pervasive, and has real-world impacts on decision-making and judgment, but that doesn't translate to measuring the effect of implicit bias post hoc in an actual criminal trial or legal proceedings. Although the Attorney General hasn't challenged Simmons, and indeed actually argued in Simmons that the RJA violations were not subject to the usual harmless error analysis, the California Supreme Court has recently requested briefing in 3 capital cases on this issue. The High Court's ruling in these cases may have a profound impact on whether the RJA proves to be a powerful tool in addressing racial bias and discrimination in our state, or simply a well-intentioned thought experiment that has no teeth. The procedural obstacles that I just mentioned not only impact the effect of the impact of the RJA, they also redistribute the burden of calling out racial bias and discrimination. The legislature clearly intended to effect systemic change, and that necessarily requires the participation of courts and prosecutors. These procedural barriers, however, make the defense, including a person charged or convicted with a crime and their counsel, entirely responsible for raising claims and bringing about meaningful system-wide change. As the RJA law is unfolding, it's telling DAs and trial courts that they have no obligation to act affirmatively to prevent RJA violations. Rather, it's entirely up to defense counsel to object and preserve claims for appeal. There's also been a significant lack of guidance on A3 and A4 disparity claims, as staff has mentioned. The language of this part of the RJA has yet to be definitively interpreted, and litigants do not know what they need to do to prove a violation. As a result, courts have rejected claims that rely on statistical evidence, even when and aggregate data, even when that statistical evidence has controlled for relevant legal factors and considered similar cases. This demand, in effect, for both qualitative and quantitative evidence in every case subverts the legislature's undeniable intent to move past the unattainable burden of McCleskey. So I appreciate the committee's continued interest in the RJA, and I hope it helps persuade stakeholders that bold action is required rather than a default to past practices that are responsible for the racial bias, animus, and disparities we see today. Thanks.
Thank you so much. With, again, the huge caveat that we cannot, well, first of all, I think we're all going to acknowledge racial bias is pervasive in the justice system, and I don't want to try to relitigate that or need to prove that up one way or another. And I think that we also share the idea that we want to eliminate as much of that as possible. And we also share the idea that that's very difficult. I also want to acknowledge California for being out front on this. I think that we have done a good job in terms of trying to address it, and a poor job in actually implementing the statute that we have on the books. Our challenge, or the way that I want to, hopefully the committee, is to be as practical as practical as possible in moving this forward step by step, and really making very discrete recommendations. So that's my goal for today. This is not the only time that I'm sure we're going to revisit this again and again and again. So with that preface, does any committee members or staff want to start the conversation?
So, I have a question. There've been a couple of different comments about data. And obviously, this is something that our committee struggles with generally, but specifically with regard to race and gender and other areas where we know there are significant disparities. I'm wondering if I'm wondering if the panelists have any concrete suggestions, beyond the legislation that's already been passed regarding data collection and distribution, number one. And then I have a separate question that hasn't yet been raised, but my primary question right now is about data collection, dissemination, and use.
Thank you. Before you get to your second question, I want to piggyback on your first and point it to, I guess, starting with Ms. Lashley Hayes. In particular, in your statistic-based, data-based, in the initial pleadings, can you describe what data you were able to use, again, pre-discovery, what do you have access to, and what has proved successful? And please, if you would, then continue to answer Professor Ochen's question.
Sure. Yeah. Thank you for that question, Priscilla and Michael. So what we have access to is, and the way that I brought that claim, or just speaking generally about claims that I've brought, a lot of it is obtaining data through the district attorney's office via CPRA request. And luckily in LA County, they are quite responsive. There is an attorney that is assigned to responding to CPRA requests, and I feel that they are fair in their responses. Other counties, that is not the case. Other counties, there are CPRA requests made to various agencies and they go ignored. And that is a chronic issue. So LA County, we receive a lot of it through CPRA requests. I've also done CPRA requests to CDCR and received a good amount of data there. Yeah, Mike, did you have a question?
And specifically, what are you asking for? You're obviously not asking for, give me every charging, every whatever, can you just give us a kind of a narrow?
Right. So let's use juvenile, my challenge, which is kind of my obsession right now, which is
Okay.
challenging juvenile direct files and transfers, because the rampant racial disparities that are very obvious with that data. So I will ask for, what I asked for is give me every case where a child under the age of 18 ended up in adult court. And I asked for from 1980 to the present day. And I did that because I've had conversations with the people, the data people in the LA County DA's office. And I know that's when they sort of, or I did it based on juvenile, what was going on with juvenile cases then,
And
Um,
sorry to ask, you ask for every case, and I guess you ask for the charging, the race. I'm really trying to understand what
Correct,
you ask
correct.
for.
I mean, I don't wanna bore everybody. We could always have a follow-up where I can show you examples of what I do, but I don't wanna go through. I ask for very specific things, I may get some of that, I may not get some of that, right? Um, but what I am looking for, and the challenge is trying to capture both the cases that get filed and then the similarly situated cases of essentially white people or non of that person's race that don't get filed, right? Um, but there's a huge challenge there, okay? Because the non people of color sometimes don't even touch the legal system. Even though they might get stopped by the police, sometimes they don't even get arrested. And so there's a major problem with proving similarly situated.
I completely understand that. Once you get the data and you see 10 times as many black people for the same crime, is that when you file, or do you do the type of um, consideration of other factors? I don't know if you were listening when Steve Raphael was here, or do you just say 10 times as many black kids charged with robbery going to adult court, and that should be enough? Or do you say you try to eliminate other factors?
So it's changed over time. In the beginning, that is essentially what I filed with, and that was typically enough to get past prima facie. Typically, the numbers alone on that basis were kind of shock the conscience enough for most people to realize that there's an issue, at least for prima facie, right? I think we are seeing a shift. Lisa mentioned sort of a shift in where we are right now. More recently, I've given data to an expert, a qualified expert, had them perform a data analysis, looking at felony filings versus misdemeanor filings in same cases. They wrote an excellent report based on a data analysis, and that wasn't found to be enough to even get me past prima facie with an expert report. So the law is changing, the bench is changing in the way that they are perceiving these cases. And as I indicated earlier, the the bar keeps getting raised and raised and raised for us. So it's like, oh, that's not enough. Oh, that's not enough. Oh, that's not enough. To the point that it's becoming, as I think Lisa indicated, more of an ideal and not something that is even a realistic litigation in court.
Priscilla, I jumped on your question. I don't know if you're
Yeah, no,
the second one too.
yeah, no, so I want to just kind of second what Elizabeth is saying about the barriers that the procedural barriers that are being erected to substantive relief under the RJA, particularly at that first stage of establishing a good cause to get data, number one, and then two, at that prima facie stage. These are not supposed to be based on the plain language of the statute and its history. These are not supposed to be onerous, right? These are supposed to be opportunities for the litigant to get information so that they can press their claim in the first instance in terms of showing good cause. And that first stage in a prima facie case is not supposed to be onerous, right? And I think Judge Espinoza or Judge Cousins, I don't know to what extent you're familiar with this, but my sense is I don't think a lot of judges in criminal cases deal with statistical disparity analysis a great deal. And I also think that many judges probably think the RJA is not good law. Not good law as in it's not valid, but it's not a good substantive law, and are putting barriers in place, again, to substantive relief. So I am very concerned about that. And I think we've heard that from a number of different witnesses and experts. The question that I have is before we even get to an RJA claim, I have heard from defense attorneys that some DA offices are requesting RJA waivers during plea negotiations. And this is particularly to the public defenders, Lisa and Elizabeth. Is this something that you have heard of? And if so, can you comment?
We've gotten that. That's common.
And that seems to me to be a serious problem as well, because this should not be, I'm sure there are a lot of other waivers, but it would, I think that that is one that's particularly problematic, and probably probably the biggest issue for me at this point, given the volume of plea bargaining in our system.
Lisa,
Um,
We are hearing reports of exactly that, of prosecutors asking for waivers in order to provide, to offer favorable plea bargains. We're also seeing we're also seeing judges asking clients to drop RJA claims in order to get favorable outcomes. I think that's a more difficult prospect for defense counsel, because in some, the goal really is to get the best outcome for your client as possible. And if that's dropping the RJA claim is the best way to do that, then it puts us in a difficult position, but we have to do what's best for our client. Elizabeth, what's your experience with that?
that's not happening in LA County, but it's definitely happening elsewhere, right? So it is, I don't have personal experience, but yes, to both of those things that were mentioned. Can I go back to echo one more thing, Priscilla, that you were bringing up about the challenges and, requiring such a high burden in even obtaining data? I want everyone to be really clear that, and understand that how much more of an issue it is for a pro per client in prison, right? And those are the folks that I, stay up at night and can't sleep over, right? Because they are doing their best, right? And trying their best. And let's say it's a very sort of obviously good case for a data disparity type claim. In my book, that would be something like one of the guys that I got released was sitting in prison on an 11-350 possession. He was in for like 36 years on a 3 strikes, right? And that is a guy that really needs to get some data to be able to show his disparity and how 3 strikes, Mike, this impacts people, right? But let's say that guy can't get counsel, right? And then he tries to write something, and I've seen some pretty good ones, right? That guys are writing from prison. Sorry, I say guys, but it's mostly guys, right? I've seen some good ones where they try to attach reports and they're still not getting counsel and still getting denied discovery. And that to me just seems patently unfair, right? And also the folks that are rising to the top from prison are all the guys that are higher education, don't have mental illness, don't have an intellectual disability, which to me is just patently unfair, right? Just because the squeaky wheel of the guys in prison may get some action, what about all the guys with mental illness? What about all the guys with intellectual disabilities? They are getting absolutely no relief on RJA because they can't say the right thing initially to even get an attorney appointed. So that's a chronic issue that I think could be possibly addressed by the penal code revision of clarifying when people have a right to an attorney.
This is super helpful. I'm going to turn to you, Judge Cousins, on a couple of things we've just been talking about. Well, first of all, I'm going to make another plug for our forthcoming dashboard, which I think will help resolve some of these claims. Obviously, people who are incarcerated don't have web access, but it's a first step in transparency. Judge Cousins, when somebody comes forward and says, I'm Black, and Black people get 10 times the sentence than white people for robbery in Riverside County, should that be enough to trigger counsel and discovery? I I hope we're all of the opinion that for the initial claim to get an expert report the way that Elizabeth was describing is not what anybody wants, intends, or is practicable. But perhaps some of these broader claims is here's data showing there's 10 times that Black people get 10-year average of 10-year sentence, and white people for robbery get an average of 1-year sentence. and that should trigger it. Is that your sense about the way things should be going? Is there a way that in your mind that we can legislate that or create rules that help move things along? Does that question make sense?
I think we are seeing the sort of the courts trying to flesh that area out, and I think there was at least one case that talked about as you get further into the process, the level of showing goes up. And I think that's the proper way to do it. I think the entry level claim should be almost based solely on the allegations of the petition. I mean, it's and if it articulates a claim, then you're sort of in the door. And
And by in the door, does that mean that you get right to the discovery? Because in the door, because the data is the discovery, and for those who are practicing this more common than I am, and correct me if I'm wrong, is that what we really need to prove the next steps is the real data that you're getting under a Public Records Act request, but would be very difficult for somebody. But just to allege I'm black and I got a longer sentence because I'm black, that doesn't seem, is that you think enough, Judge Cousins, to trigger data discovery and appointment of counsel?
I'm a little concerned about that for the discovery level. Uh, I do have a feeling that there ought to be a little more of a showing than simply the allegation. Uh, and how a person will practically get that, I understand counsel's concerns and the difficulty of the pro per defendant in custody. I, I don't have a good answer for that. But the problem is, if you're triggering the discovery obligation is triggering an enormous burden on the system, and to do that, I would think there needs to be something more than saying just because I say it, I get it. I think there needs to be more, and for coming up with that balance is very difficult. I also think a big part of the problem is that when it comes to the database claims, judges are not statisticians, and we don't understand that process. I know I don't. And it's we
We
need,
all
I
went to
think,
law school assuming that that was not going to be a problem.
yes, that's why I became a lawyer, not an accountant. So, but I think a part of our system owes the system a trained judge, a knowledgeable judge, at least about the basics of data. And at what point do things become statistically relevant? What do those concepts mean? Um, so at least there is some indication in an informed judge that this is a case that at least seems to have a colorable claim and should be pursued. Um,
Before we get to Heidi's question, which I see your hand, but Judge Cousins, are you in agreement that um, we shouldn't be having to retain experts and doing these regression analyses before getting the data? Like that seems a little bit the cart before the horse, to me at least.
I would agree with that. I think
Okay.
that's over the line, and appropriate for the next level, perhaps, but not for the initial showing. No, I think that's unfair.
I agree with that. I'm gonna, again, before Heidi jumps in, express a little bit of my skepticism that we're going to be able to train judges sufficiently in the numbers that need to be. And I want to throw out the idea of maybe some sort of special master, or that could be the mathematician that we all need, that courts might be able to rely on in different counties. With that said, Professor Rummel.
I definitely went to law school because I wanted to avoid any more math classes. But I'm curious, maybe for Lisa and Elizabeth, how these discovery requests, like how distinct are they? I mean, are we regenerating the same data about how many African Americans got charged with guns enhancements vis-a-vis non-African Americans? Like, is there if we have just certain categories of data, could we collect it and publish it for everyone's use in evaluating whether they have an RJA claim? Is that within the realm of possibilities?
I mean,
Of something that might
theoretically it
ultimately be
is.
more cost effective than the individual.
Go ahead, Elizabeth.
Oh, no, go ahead, Lisa.
I was just going to say, theoretically it is, but we've seen situations, especially, for example, in Santa Clara, where the data is provided with protective orders so that it cannot be used in any other case. So it can't be made available, it can't be shared, and it gets very, very difficult.
But the data doesn't include any specific individual private information. It's just empirical data, right?
And isn't, even if it does include information, I'm sorry, isn't this almost all open court data? Like, how is this, correct me if I'm wrong, what?
Well, again, it varies by county. Some DAs will only give up anonymized data, which again, in theory is totally appropriate, because to analyze an RJA claim, you don't need to know who the person is. But in real world practice, if you don't know who the client is, you really can't verify the accuracy of your data or get additional data.
Right, but everything that's ever been, I assume that everything that we're getting has been filed in court somewhere and is a public document, and therefore, oh, no, Elizabeth, you're shaking your head. So some of this is legitimately private stuff. Okay,
And
like for what? Arrest
Because
reports?
if you think about it, it's what I said before. To do the similarly situated, there has to be people who were arrested but not filed upon. So I have a case where the judge ordered that piece. Those names cannot be revealed because they never had a case that went to court, right? So it became a
So
half and half.
arrest reports we're talking about. And arrest reports are not filed publicly. They are not generally available to the public.
Well, he ordered that people who were arrested who did not get a case filed, those were going to be private because, they have a
I
right to
appreciate
that.
that that's what happened in your case. What I'm guessing is, and I'm asking, I guess, Lisa in the Santa Clara case, it seems like if a case is filed, it's public record. I don't know why they could have any right to protect it whatsoever, but.
I mean, in most cases, yes, the data is public that we're asking for. Unless it does get tricky when we get into the issue of prior criminal history. That has some particular privacy restrictions. Again, I think those could all be resolved, but we end up fighting over these issues instead of looking at big picture questions.
Got it. I have a million more questions. Mr. O'Connell, you've been quiet. I was wondering if you have any particular, before moving on, insights or ways that we might be able to be helpful over some of these thickets that I think that you share. I assume that you share the concern that there's a big burden on prosecution offices, but also want to try to make these cases move along more efficiently.
Yeah, thank you, Michael. I agree with my colleagues that the discovery requests, and whether that's through an RJA discovery motion or a California Public Records Act, we will comply with that. That's the law. No DA's office should be having difficulty doing that. The records request, and this is where I think we get this sort of perfection is the enemy of progress. Discovery requests that I universally receive in our office will be for 10 to 20 years of all cases, the name of that individual, the date of the arrest, whether that individual had any priors, who was the referring agency that came from, who was the reviewing district attorney who looked at that case, what were their notes on the charging decisions and the filing. List all information relating to the victim, their race, ethnicity, their age, where they lived, where the crime occurred, whether that individual had a weapon on them, all forensic reports, all investigative material, any emails or communications which were written. I could go on, but you get the point of why this doesn't get done in a timely manner. Because, and maybe the courts are responsible for this or can give us some direction on this. I don't think we need that level of discovery in order to make a prima facie finding that race was potentially a contributor to how that person was prosecuted and ultimately sentenced. And so we have, all sides have become so bogged down in courts giving direction. You need more than what you have. So I don't fault the public defender's office for asking for more. I certainly hope that my colleagues don't fault the district attorney for saying, I need 6 months if I'm going to get 20 years of homicide materials to you of that level of specificity and detail with that level of private information about that. We have to simplify this in order to get past that.
I totally agree. And I am particularly sensitive also. I check myself on the what's public, and especially addresses of victims seems pretty um, um, private. Should
Yeah, and
remain.
that's no fault of the public defender. They're being directed by
No,
courts. You
of
you
course.
need to get more, right?
Is there a way, perhaps this is a question for Tom / Steve / Judge Cousin, is there a way that we can say these 5 elements are not private, have to be given, and are sufficient to get a prima facie case? Is there a way to I don't know, even legislate that? Would that be helpful? I guess first of all, is that possible, Tom? And to the rest of you, you think that that would be helpful?
I think that is the key question, because if you only need to know 5 things, then that's all you need to learn, and hopefully they would map on to the things that are commonly tracked in a case management database, so it's relatively simple and doesn't require looking at underlying reports or getting correspondence or all the stuff that Simon just mentioned. I think the thing that is striking to me about the 2 or the 3 data-based claims that have actually gone to a decision after evidentiary hearing is that in the 2 that lost, the courts are like, these reports suck, basically. It's not even enough for me to even really engage with the legal questions. So I don't know if that's because those underlying experts didn't know what they were doing, or if the courts are just, the lawyer brain is just never going to engage with the math brain in a really fundamental way, no matter what, or if something else is going on. So I think figuring out what exactly needs to go into the analysis in a reasonable way would help to solve a lot of these problems, because if you don't know what you need to show at the evidentiary hearing, you don't know what you need to get in the disclosure, and because it's sort of a vicious cycle between those 2 things, it seems to be causing an escalation on both sides of saying, we're not going to give you anything because we don't want to get into this disclosure battle, and then once you start asking for disclosure, you ask for everything. It's becoming like civil antitrust litigation or something.
Right. I'm focusing on trying to get into the first over the first hump. Priscilla,
Michael,
then
could I
Heidi,
offer a solution on that?
hold on. I just do want to, in order of my
no
hands
problem.
raised, at least on my computer, as I see Priscilla, Heidi, and then you, Simon. So
Fair.
why don't we
Sorry
go
about
that way?
Simon can go ahead if it's on this thread, because I'm going to take us off in a different direction.
Here's where I think the legislature could help on the statistical quandary that everybody in the room, I think, is readily identified as not strong at math on this. We have oftentimes a denominator problem, which for those of you who are doing math there, that's the bottom, right? Sometimes a statistician will use general population data, and then a court will say, well, you're asking about probability of chance. What's the chance of Simon O'Connell as a white male living in Contra Costa County being charged with a special circumstance homicide? Shouldn't the analysis be if Simon O'Connell has committed an eligible crime for special circumstance homicide, shouldn't it be that denominator of that classification? I think if the legislature were to give, and then it becomes a battle of an expert, one did it, one didn't do it, the judge either likes somebody's denominator or doesn't like their denominator, doesn't agree with probability of chance over statistical likelihood, whatever these jargons are, which we are not experts in, if there were just a common threshold that every expert would have to utilize as this is the standard which would be applied as the denominator factor, I think that would help everybody sort of know, okay, what is the price of coffee at Starbucks in this jurisdiction? And we'll all be better situated for that. The other opportunity is that we rely on court alienist experts in 1368 proceedings and 1026 proceedings, and to have a neutral report. Could there be an opportunity for there to be an alienist statistician who is not hired? And I'll tell you guys, it's alarming how much all of our respective offices are paying for statisticians. I should have got a PhD in math, not an JD, because it costs $30,000 to $40,000 to generate these reports and then testify to all of this. Elizabeth, I don't know if it's the same cost in LA as it is the Bay Area, but it sure isn't cheap, and there sure aren't a lot of them available. And so I think as we look for solutions on this, and trying to think outside the box on easy ways to maybe get somewhere, I offer those up.
Great. Priscilla, I'm going to hold off unless you're changing topics, but Heidi and then Lisa, if you're still on the same topic, and then we'll go back to Professor.
Yeah.
Mitchell.
I did have a question on this topic that just
Oh,
occurred.
sorry.
Go ahead, Priscilla. Go ahead.
As we think about, clarifying the standards for showing of good cause for discovery and then the prima facie case, and maybe this is a question to whomever has the awareness or knowledge is, are we looking to other areas where we need to make prima facie cases, like employment discrimination, for example, right? That's an area under Title VII where, judges are familiar with the burden shifting process of I produce a showing, it goes to the defendant, or in this case, the defendant, to say, well, yes, there's a disparity, but there's a good reason for it, and then shifts back to the plaintiff, right? And that seems to be something that courts have been able to do for, hopefully the foreseeable future. Hopefully we still have a Title VII. But I'm just wondering, are our courts looking to outside of the criminal legal system for support on how to address the burden shifting process that the RJA requires?
Judge Cousins?
I don't know how to respond to that. I
Do you think it's a good idea? Let's say do you think
I
it's a
think
good
the idea is great. And I think the suggestions that the prosecutor made were great. I think some standardized guidance would help tremendously. It would cut down a lot of the casting about in the woods trying to find a direction. So I like that. But as to whether that last concern is expressly addressed with the courts, I'm not aware of anything happening that does that.
I agree. I don't think it's happening yet. I was just wondering if seems like a good model. Professor Rommel.
Yeah, and this is why I asked the original question, like what data are we getting and what does it look like and how universal is it? But I like Mr. O'Connell's idea, just to take that maybe one step further, either the legislature or like your idea, Mike, designated neutral special master. We decide, not county by county, judge by judge, defendant by defendant, but we decide this is the relevant data to make a prima facie case for an RJA claim. And every county is required to collect that data, and it's in a public space in a way that it can be public for access by people who are incarcerated in public defenders' offices. And it might not capture every case, and there might be individual cases where you have to go further, but there are some basic premises: who by race, who had gun enhancements, by race, who was transferred to adult court, by race, who got a special circumstance allegation instead of just a first-degree murder. There are some broad categories where we already know there are racial disparities, and if we did collect that data in a way that there was some consensus, I'm not going to, I don't know how we get to that, but a reliable, instead of just waiting for courts haphazardly and spending all this money and all this litigation and all this effort, it gives us a really good starting point. And it would be great information to have in the public realm. Like, why wouldn't we want that information in the public realm?
Lisa, I'm curious about your reaction to all of this, and your whatever question you might have or initially raised your hand to.
Yeah, no, I wanted to comment. I have a lot of thoughts to these different threads. One is there some kind of common threshold we can use? I think that's a great idea to explore. The caveat is that every case is different, and so it's hard to come up with a formula that will work for every case, but I think it is important. In terms of special master or experts, the RJA does allow a trial court to appoint an expert to help him or her understand the statistics. To my knowledge, no court has done that to date. In terms of the civil cases as an example, we have looked at them, and I think there are lessons that we can learn from civil cases, but it's not an exact match because the burden is so much lower in RJA. The burden is really supposed to be prima facie is very low, and then we go to evidentiary hearing where the defense keeps the burden. Whereas I think in civil cases, the burden is higher at prima facie because what it means is once you make that burden, it's then the other side's burden to refute your case. And if they don't, you win. So we still have the burden when we go to the evidentiary hearing. So it's supposed to be a very, very low prima facie burden. But I do think there are lessons we can learn. But I think an overriding point is even if we get all of this data perfected and we get the formula perfected, we're still coming up with a really crucial issue, which is that some courts are interpreting the disparity claim to involve more than statistical data. They want to see factual narratives of cases. So I, for example, litigated a case of special circumstances where I provided not one, not two, but 3 regression analyses controlling for every factor we could get our hands on in the data. And the court said, well, that's, I'm not going to even consider that because you haven't shown me how there's another man out there who is just like your client, but a different color. And my point was, I've asked for that data. It's not available. I don't have access to it. How would I do that? And from a scientific perspective, social science perspective, I don't know why I would need to. So unless we can get that part of it fixed, all the data in the world is not going to help us.
Gotcha.
And
Before I get to you,
just
Elizabeth.
on that point, I just want to say I think there is a challenge with the RJA because I think a lot of judges want to bring animus into because I think that's basically what you're suggesting is the judges want to see some kind of narrative of intentional discrimination or animus, right? Even in the statistical disparities realm. And I think that is a major challenge because again, going to the civil side, there is a huge hostility, and there have been studies done about this. Judges just sort of not believing discrimination exists based purely on statistical evidence. And so they are implicitly or explicitly requiring some kind of showing of animus, which is not required by the RJA, and which would speak to the sort of hesitancy that Lisa was just describing.
I want to get back to the narrative piece in a second because I have a specific question in regard to the statute. Before I do, Lisa and then Elizabeth, this idea of to achieve a prima facie case, this is before we get experts and all that. Do you think it's possible that we can agree on 3, 5, 6, whatever the number is, of discrete areas that do not approach issues of privacy that could be statutorily mandated that those have to be given? You think that that's possible in a way that would actually expedite things, or are they too disparate, too many different variables and too many different cases? That's not. I'm not thinking. Tell me, I'm not thinking clearly enough.
Well, I mean, can you guys hear me?
Yeah.
Okay. I mean, your question is very similar to what Heidi just asked earlier. She said, are there groupings, or are they sort of all over the place? And is this not possible to have what I'm calling a central repository, right? And so I think the answer is yes and no, right? So yes, we have more frequent categories like the frequent flyer categories, right? That most counties are pursuing, lots of claims around it. As Mr. O'Connell said, the capital cases, which one gets filed with a special, which doesn't. But then we have every little obscure case in the world that needs its own data set, right? So I do think there is room to force, and legislate transparency and that DA's offices are required to monitor race and filings and this, and this, that could then go to a central repository. I really like the idea of not a special master, but a group of experts. Maybe I think there could be a small group of experts that take that centralized data and analyze it, and that everyone could agree on that, right? I mean, a prosecutor and I had a conversation about this, and we were in full agreement. You know, he said, why am I running all over trying to find data for pro per habeas clients? And why are you running around trying to get the same data? And like, it doesn't make any sense. And we both sort of said, if we just had like one hub, you know, that we could like go to, now that would work on some cases, but not on others. You know, then I have some that are so obscure and so detailed that,
I
so
think
I
we're all
like the
acknowledging,
idea. I like the idea.
I think we're all acknowledging that there's always going to be detailed cases. I guess what I'm trying to focus on is, are there things that we can do that would address a large bulk of them to at least get those going? Professor Ochin and then Lisa.
So my question has to do with something that was raised by a couple of folks, which is remedies. So assuming folks can, put a showing of good cause, assuming that they make out a prima facie case, and assuming that they prove they meet their burden, preponderance of the evidence, right? Um, a few of you mentioned that judges have been hesitant to impose remedies, and there are obviously legal questions before the California Supreme Court about, when a dismissal is appropriate, or when, changing a sentence from, the death penalty or life without parole to, a lesser sentence is appropriate. I'm wondering if there are ways that the committee can support the imposition of remedies when they are appropriate, setting aside what the California Supreme Court may do. But I am wondering if there are any thoughts about remedies, and then that's my first question. The second is, what are prosecutors, so maybe this is a question for Simon, what are prosecutors doing when, in the rare instance, someone makes out a case under the RJA? Are prosecutors then looking at, say, we've been talking about, gun enhancements. Let's say someone who is Latino makes out a claim regarding gun enhancements in Contra Costa County. Are you all then going to look at others who are similarly situated to that person to ensure that they too weren't impacted by racial bias? Or is it, this is a single case, other people can get in line? How are you responding when there is a case that is validated in the court?
Great question, Priscilla, and thank you. So we have had several cases which have been litigated. I think there's an import of having cases litigated in order to sort of know where the tide is on what a remedy would be. That was really important for us as a threshold question on a special circumstance homicide case, in which factually it was egregious. 37 rounds fired by at least 3 and likely 4 shooters into a car with 2 individuals who were rival gang members, lying in wait for close to half a day after they had indicated that they were going to go out and execute those individuals. And we had a massive RJA that was part of that. Ultimately, once the findings by the court were made, we then resolve that case because no one had doubted the responsibility of those individual. And you can have 2 truths at the same time: an RJA violation, as well as an egregious homicide which occurred, and a need to strike a balance. And I'll remind everybody that unfortunately, we also see a disparate impact in the color of those victims as well and their families. And I struggle with the fact that we want to rectify historical racial bias on those who are charged and prosecuted. We also have to recognize that depending on the color of that victim, you may very well see a different outcome as well. and that is equally problematic. And so I try to be conscientious of that. Priscilla, we do take, and I'll give everyone some hope as we sort of perhaps we're getting close to wrapping up here, is that I think prospectively, and this is where the RJA has had the biggest impact of immediacy, that you may not see in cases going up on appeal and the historical litigation that is going on. Prospectively, we are far better as prosecutors in identifying what might be rhetoric that was once used in court and was found to be an analogy that was maybe helpful to utilize. There now is direction and training for those prosecutors. There is guidance from the RJA, and the courts are very good at following through with this isn't a permissible utilization. People are trained that way, and I'm seeing far less of that rhetoric going forward. And that's an accomplishment of the RJA. And everybody who was a participant in the creation of that can say, going forward, we're better than we were in 2021, right? That's great. What gets difficult is the post-conviction forensic view of a case. And I think this is where a lot of people have trouble because doing any type of forensic work is incredibly complicated. For those of you who are old enough in the room, in the 1970s, referring to an indigenous person, one may have used the term they are Indian. 20 years later, the appropriate, culturally accepted, and taught in education term might have been Native American. We now today say indigenous people. And so it's difficult to look at a transcript from 20 or 30 years ago as to what might have been culturally acceptable at the time, either statements or perception, and how that is equated into an RJA issue. Can't be solved today. All to say is it's very complicated on the back end. It's far easier, Priscilla, when we do have a known quantified violation to then address that prospectively going forward on cases. And so that doesn't show up statistically, but it certainly shows up in outcome and effect.
Can I follow up on that a little bit? But like for like the Wyndham case, I was from Contra Costa County. As a result of that, did your office go back and look at other people charged with that special circumstance, or was that sort of a one of? That's sort of what I heard Professor Ocean's question being more about.
Right.
So there were actually that also is the case that dismissed, but that was a very that involved very racist texts from the Antioch Police Department that were undeniably an RJA problem. I think the statistics-based claims and how those will sort of percolate through the system
right.
present an interesting question.
Tom, you're absolutely right. There were sort of two parallel paths which crossed over. There was the initial statistical charging claim, and as that was being litigated, it came to light then what is the A1 expressed racial animus directly relating to that case. Ultimately, how that was litigated, it was sort of taken as a two-step approach. The court first addressed the statistical inconsistency and the outcome. A special was dropped from there. Then with the racial
right, and then at that point, was there any reverberations beyond that case, just on that issue?
There was. So there was a couple other cases that also had the lying in wait special and the gang special, which were also remedied accordingly. What gets complicated on that is at least one of those cases also involved the Antioch Police Department on that. Okay. So, but yes, specifically, once a known statistical violation is in existence, we are conscientious about then subsequently remedying that going forward.
So you said subsequently, but do you look at cases where, say, someone is currently incarcerated, right? So
or choice, Professor. Sorry, I apologize.
Yeah.
So, yes.
So so are you doing that across the board, or yeah, how is that working?
So if you're then saying, are we then opening up all cases? We've probably got now another dozen cases on homicides of special circs, which are being litigated. Now that's for prima facie, right? And then if you're actually going to get into the case specifics of that case, then you're getting into sort of the apples to apples comparison that may have been referenced earlier of like, okay, what were the circumstances and nature of that? In the Wyndham case, probably the most egregious lying in wait situation that one could ever have, waiting 3.5 hours with 4 loaded firearms until your rivals come out of the house to shoot them 37 times in a drive-by shooting. I'm not expecting one to have such comparative facts as that, but certainly we look at, okay, what was the special that was charged then and where is it going? We have robust litigation on this and compromise. The question was raised earlier about RJA waiver. There are several cases that, and I actually think RJA waiver is, if it's universally being applied, that's completely wrong. But if you're in the middle of RJA litigation and it's going to take another 12 months before that case be resolved, and everybody recognizes that there are concerns about either the animus, the sentence, or the charging based on statistical information, and to say this now case is being resolved for the following lower term or striking of enhancements in light of the RJA litigation that was ongoing, I don't see how that is an infringement upon anybody's access to RJA litigation, because in fact, it was contemplated as the very basis for why that was going. Now, if it is, hey, I'm taking a plea on every DUI, and every DUI I take a plea on must include an RJA waiver, very distinct. But I just wanted to, and that would be problematic. I absolutely would concur with that. But I just wanted to make that distinction for everybody, because we have taken RJA waivers. Ultimately, in some of those very serious cases in which RJA litigation was going, it was post prima facie. We certainly wanted to bring recognition to the court, as well as the record for finality purposes, as to why that drastic reduction in some circumstances of cases did take place.
Mike, I think you're muted.
I'm muted. Lisa.
Yeah, I'm going back a few questions, but Mike, I wanted to respond again to your question about whether we can come up with some kind of formula or basic prima facie level. And I think we can. I mean, yes, it won't apply to all cases, but I think if we give it some thought, we can. Because basically the comparison is always going to be cases that were charged at one level and cases that could have been charged the same way but weren't.
Well, I want to, is there a difference? And in my mind, there is, that it's easier to do what I think is the A4A cases, not on charging decisions, but on sentence lengths. That seems to be less complicated. Am I correct?
I think it could be. We just haven't seen many A4 claims litigated, but yeah, it should be less complicated.
Okay. I want to get to that in a second. Okay, I have a couple of questions, and hopefully this conversation is great, and I think it go on for a while, but I'm sitting on a couple of questions here that I want to make sure I get aired. First, Judge Cousins, there's been a handful, maybe handful's too many, somebody correct me on the number, of OSCs issued by the Supreme Court using the data that this committee has published. I think the data that we have is not even county specific. Correct me if I'm wrong, Tom.
No, it is.
Okay. On just, but not crime specific, but just the applicability of 3 strikes
Right.
by county. You, without decisions, the Supreme Court, how many cases? More than one? Less?
On that particular variant, I think it's maybe 2 or 3. And they don't always say exactly why they're doing what they're doing, so it may be in more cases as well.
Correct. But Judge Cousins, is there anything that we can or should read from those OSCs?
I don't have a strong reaction to that, other than to say it's bad business to anticipate unspoken words from the Supreme Court and try to ascribe a particular direction from them.
But what if they're saying they're issuing OSCs to, let's say, a black defendant who's prosecuted under the 3 strikes law in Los Angeles County? That's all the information that we know, and that we know that more black people are serving 3-strike sentences in LA County. That was in our report. Based on that alone, they're issuing OSCs. Should that be precedent that every Black defendant in Los Angeles County, or I think it's Sacramento County, or whatever county it happens to be, gets an OSC, meaning an attorney, at least an attorney, and probably discovery?
You know, should it be precedent? No. But is it going to affect the preference? Ask any one of these defense lawyers, and they're going to say, that's giving me a big tip. And I would be remiss not to pursue it.
Well, and it's not legal precedent because OSC without a decision isn't precedent. Is it even citable?
No, I don't think so. It shouldn't be. I mean, I've never heard anything at that level being citable for precedent.
Precedent may be a strong word, but
I mean, it's certainly an indication. And
Okay.
you might, as a defense counsel, you might be, or a judge even, in considering some of these issues, be remiss in not sort of saying, this is sort of indicating somewhat like where the Supreme Court is going. I ought to pay attention to it. But that to me is a reach.
I don't know how I can't. I agree with you on the one hand that an unpublished opinion from the OSC is a reach. On the other hand, they did say that in this case, which applies quite broadly, that I mean the facts are quite broadly, and that they're using pretty aggregated data that is published and out there. That this person, of which there are many people in the same situation, are entitled to an OSC. Seems to be quasi-presidential. Peter, I know that you've hung up your robe, but I was curious
Well,
what your take is on that.
You know, maybe the closest analogy is it's like dicta. You know, it's sort of there, and dicta from the Supreme Court is entitled to a lot more consideration than dicta from courts of appeal, perhaps. I mean, so you give it great consideration, but uh, there's so little information that goes along with that OSC other than that bare statement where
That that gets
the
us
parties are understanding of the greater issues, perhaps, but beyond the parties of that particular litigation, uh, I don't know.
pretty basic to me on those cases. On those again, I'm focusing on the 3 strikes cases, on the OSC cases. They don't seem very specific to me.
Yeah, I understand what you're saying, and it certainly gives me pause, but God, there's got to be some limit as to what we have to rely on. I don't know anything to say more than that.
Okay. I was also wondering your take on sort of a class action-ish style approach here. For example, gang data, the gang enhancement data seems particularly problematic, or let's just say racist. Can you imagine under the RJA or some other vehicle that a class of people charged with gang enhancements from a particular county during a particular period of time, perhaps for a particular crime, let's call it robbery, could join together in a single case? Do we think that's a good idea? Let's start there.
Are you asking me?
Yeah, I'm starting with you because you're the dean for dean for the day.
Uh, it has a superficial appeal, but the problem is when it gets right down to it, the individual cases are so different and the circumstances so different. Um, it gives me pause, and it seems to me that the amount of complexity and the amount of judicial time to be taken to litigate something like that would be outweigh the benefit of having the class designation. I don't know. I'm concerned about that.
Okay. I was wondering if the public defenders and perhaps Simon wanted to weigh on that.
Yeah, just real quick on the concept of a class action. I have to agree with Judge Cousins, or I'm pleased that I agree with Judge Cousins because he's far more well versed in these topics than I am. But I think we would run into a difficulty of an individual client not wanting to be part of that class because either the remedy
Right.
wasn't sufficient enough for them. And so I think you would end up just having those who missed out on the opportunity to join in. It would just become completely impossible to sustain and sort of keep in a box to say, okay, this is all classes of people. Do you want to then be joined in this? And the court is going to give individualized remedy. And I think that's important to know as to sort of, is this a reduction in enhancement? Is this a lesser included? Is this the striking of an enhancement? So just too many complexities and variables there, I think, truly.
I understand you have to go. I'm not a class action attorney, but I assume that all these individual circumstances play out in every class action case. With every car that backs up by mistake, everybody has a different grade of driveway. But Lisa, I'm curious on your take on this.
The defense bar has been discussing these questions, and we're looking at different models. And I think it would be wonderful if the committee recommended some kind of fix. One possibility is that, and it's been done in other contexts in the defense in criminal cases, is that a lead case is identified, and so that case is litigated and the experts are put on. And there's agreement from both sides that everybody doesn't have to put on all that expert testimony again. They can use that expert testimony in the next case. And so cases can be handled both individually, but also collectively. So I think there are ways that we could, that could be handled. And I think it's an excellent avenue to explore.
Peter?
Yeah, good suggestion.
Yeah, I'm just going to raise by analogy what occurred with the Jessica's Law litigation in Los Angeles County about 15 years or more. As the habeas petitions started piling up, they were centralized in a single courtroom in downtown Los Angeles, and there were at one point about 2,500 habeas petitions from 290 registrants who couldn't go home or couldn't find compliant housing. And it's just something to look into, something to consider.
Right. I remember those had to be litigated in federal court, actually, if I remember correctly.
I don't remember them being litigated in federal court. I remember ultimately the Supreme Court declared that Jessica's Law was unconstitutional, I think because of the lack of compliant housing in most of the 58 counties. But my point was there was a mechanism for gathering all those cases in one spot to look at Jessica's Law.
Okay. Before we leave, I've mentioned it a few times, and at risk of opening a whole new can of worms, I do want to share with everyone a preview of our dashboard to give a sense of at least where my thinking is going, and that I hope will be of great help to everybody once it becomes public, hopefully in short order. Tom, do I have sharing capability?
Yes.
Okay. What this is our dashboard. I've already logged in. I won't bore you with how to navigate it for right now. One of the things that very much jumps out to me, I've already narrowed this down to, these are admissions to prison over the past 10 years from Santa Clara County. We can do this from every county, but I just want to use it by example. So what I was wanted to look at was everybody in Santa Clara County over the past 10 years who was sent to prison for assault with a deadly weapon, for example. All right. We already see a huge disparity in among Hispanic folks being sentenced to prison for assault with deadly weapon. But for double or multiplier of effect, I'm going to click on the gang enhancement. So this is from Santa Clara County over the past 10 years, the people who've been convicted with assault with a deadly weapon with a gang enhancement. Almost everyone is Hispanic. The size of people who are white are so small that they're less than 10 people. Is that right, Tom?
Yes.
It's suppressed. My feeling and hope is that this should be sufficient to get us over the hump to get discovery. That when you show that in X County over 10 years, such a wide disparity that is sufficient. With all the caveats that this is not yet public, I'm just curious if anybody has some last thoughts about whether or not this type of tool can or will be helpful. I'll start with Elizabeth.
Yeah, thank you so much for sharing that. And it looks like a wonderful tool. I'm glad to have sort of more data, the better, and the more tools, the better. There's a lot of those tools out there right now already. The Burns Institute runs one. The Paper Prisons runs one, right? So there's a lot of these tools. And so it's wonderful. Immediately, my brain started going, when have I done something similar, right? And what happens, right? And I can't stress enough that the opposite group that you have to compare to is always the problem. Okay. So it is, and I'm just gonna state it very bluntly, it's the comparison to the white people that is the problem. Okay. Because the white people don't get the enhancement. The white people don't get that severe of a charge. They fall under the radar. They don't go to prison, and so they're not on the data. And that's where it falls on us. And then we don't end up, we get accused of not meeting the proper standard, not proving it well enough because we're in a catch-22. The data doesn't exist for the white people. And then,
I
so
totally get that. What I'm trying to do is get beyond at least the publicly available data. And I know that even the more detailed data doesn't get to the point that you're making at. I'm
Right.
trying to get us in the door, to
sure.
get the discovery, to get an attorney, to get an expert, because that seems to be the first hard step, especially. And I'm hoping that these publicly available data dashboards at least gets us the first step.
Maybe. And the other frequent problem that this dashboard doesn't, that we need to address here and folks need to understand is that the response that often I've heard in court over 4 years from so many people is in my opinion, racist response or implicitly biased response that somebody who looks at that data then responds by saying, maybe it's only Latino people who are doing this.
Yep.
So that is the implicitly biased response that I hear over and over and over in the courtroom. So,
We're
yeah.
working on that too, at least with the gangs. I have a thought about that, which we can discuss offline. Lisa, and then we do need to kind of wrap this conversation up and try to figure out, we've gone way over. Simon in particular asked for leave, which we've abused your time. So Lisa, I hope you can help us wrap this up for the time.
Oh, I wasn't planning on wrapping up, but I will say that that the data dashboards are very helpful. They don't get us all the way there, but people are using the paper prisons and the other dashboards available to show good cause for discovery and even for prima facie as part of their prima facie showing. So they don't solve our problems, as Elizabeth has explained, but I think they take us an important first step.
And the courts have been receptive to this?
Some courts have, some courts haven't. I mean, it varies dramatically, but some people have had success using this kind of data.
And just to be clear, I'm not suggesting that this gets us all the way to relief, but it gets us to a point where we can start getting to our hands on real data with real experts, real attorneys, and real litigation. All right. Before we close, any last comments, questions, suggestions? This panel's been excellent. It's an issue that I think all of us care about, and want to try to improve the system. And anyway, any last questions?
I hate to bring up a new topic, but I think it's easy. And I want to go back to the misdemeanor point. Does the RJA do anything for misdemeanors as currently written and interpreted? It seems like the answer is no, in almost all, excuse me, all cases, unless you're having like a misdemeanor jury trial or something. But for a statistics claim, is there any point even starting to do one with RJA?
Tom, I'm going to break my rule of staying on for 2 minutes on this
Sorry,
very topic.
Simon.
No, that's okay. That's okay. They can keep knocking at my door and wait out there. So a couple things on the misdemeanor, right? So we now have race blind charging, which impacts 90% of misdemeanors which are filed in the state of California.
Right.
That's a good thing. So now we'll be able to see what that statistical information is over the next several months and how race bears out with that. So I think that's an important aspect, and that's Penal Code Section 741. Oftentimes, the RJA motions that I have seen raised on the misdemeanor level have to do with the collateral consequences of what that charge was, whether it's a DUI or whether it's a domestic violence charge, and there are potential immigration consequences. Those are already addressed by our penal code, 1016.2, and obviously the Padilla Supreme Court decision gives, and we have a robust policy for immigration safe pleas. So a lot of what does come up in misdemeanor then is going to be in trial and those aspects. I know you posed a question earlier about remedy of dismissal. I certainly don't think that that would be appropriate on the felony level when we're talking about capital murder, gang shootings, or robberies. You know, we're talking about cases of that length. At the misdemeanor level, could that be a remedy for a blatant intentional violation of the RJA? We're talking about expressed bias, which had some sort of calculus to engaging in it. I think similar to a suppression in the most egregious senses, then that may be appropriate. But that's the reasons that doesn't come up a lot in the misdemeanor, just because of the race blind charging and the collateral consequences, immigration safe pleas that exist. So those are my thoughts on that. I apologize. This has been a great, robust conversation. Michael, thank you. Tom and Joy, thanks for prepping me for this to know what to expect. I appreciate everybody. If I'm ever welcome back, I'll be sure to make it.
Thank you. And I said I was going to wrap this up, but I one note that I forgot amongst myself. Yeah, Simon, you're excused. The rest of the class must stay. Which is about this narrative issue that's come up a couple of times. Am I reading things
I'm
correctly?
sorry to interrupt. That didn't really answer the question at all, I think, unfortunately. I don't know if Elizabeth, is this part of, do you guys do misdemeanors? Or is it like, we've got enough work with the felonies? Have you thought about this at all?
Misdemeanors were problematic to pursue in the beginning, and now they are exponentially problematic in the RJA realm because of the RD case that basically said you don't have to impose a remedy. So once remedies are further clarified, and when shall actually means shall, then remedies should be, misdemeanors can be sought after. Would we do a data-based claim on a remedy? I mean, probably not in a million years, right? I mean, if it took me 2 years on a serious felony to develop a database claim, you could imagine. The only misdemeanor cases on a database level that we would go after is one that would have maximum impact, what we were talking about earlier, where it could be something that we're seeing frequently, and we know that if we litigated one to its full potential, it could impact a whole class of misdemeanors. That's really the only realistic thing with the current state of what the courts have said in RD. Once they further clarify that somebody could actually get relief, then I think we could better litigate RJA and misdemeanors.
Great, thank you.
That makes a
So
lot
in
of
other
sense.
words, misdemeanors make up, I don't know, like 85% or maybe more than that of filing. So the Racial Justice Act, as right now, just doesn't really even apply to it, is one way to kind of reverse engineer what I'm asking about.
It's a resources issue,
No,
Tom. But it
absolutely.
totally, yeah, it totally applies and it should be applying, right? But it's a resources
Well,
issue.
but I heard it's not entirely a resources issue, because you're saying if there's no remedy that can be applied, then even if you had all the resources in the world, if the court can't do anything, then it's like it hasn't been pressed because of a resources issue, but it sounds like the legal question is no, no thanks on misdemeanors.
Well, I
It's kind
think,
of
Tom, it depends on the misdemeanor. The question is there a remedy? And one issue is, will the judge impose it? But one is there even a remedy the judge could impose?
right.
Is dismissal the only remedy, or is there some lesser option? And I will say, like in Santa Clara, they are pursuing a misdemeanor case that's based on disparities, and it's not a true class action, but they've joined several defendants, and they're hoping that, if they win that case, it can be used for many people.
There's also pending misdemeanor litigation in OC, as far as I know. So there, it is happening.
What are
Lisa's
they
right.
trying to get? Like, are they looking for dismissal, or like what is the ultimate goal?
Sometimes we don't know, Tom. I mean, sometimes the RJA is there and we have to litigate it. It's a matter of sort of justice and we'll figure it out in the end, and maybe what I say to a lot of judges is, let's go through the hearing. You should hear what happened here and then you can decide. And I'm hopeful, even though we keep talking about dismissal's not a remedy, in my reading of the case law and of the statute, dismissal is still an option to a judge all the time in the interest of justice. So
Right, like a
I'm not,
1385.
yes, I'm
Okay.
not giving up dismissal as a potential remedy under RJA. And I think that we could be litigating misdemeanors and still asking for an interest of justice dismissal. I think that's well within a judge's discretion.
Well, we love 1385 on the Penal Code Committee, so you won't hear disagreement. But it's just interesting that we kind of have to make that leap for the vast majority of cases in the system, if you think about it that way. Obviously not the ones with very long sentences, but just from a numbers basis. All right, I apologize everyone for getting us into that.
No, that's a good point. Especially, we always, I think, forget bulk of the part of mass incarceration is frequently in these smaller cases, lower level cases. I want the last point that I wanted to bring up, or the last note that I had, is about this narrative issue that was brought up a couple times, and how difficult that can be without any discovery. And particularly the question was, how can somebody who's incarcerated, or even somebody who's not incarcerated, show that people from different races got lesser sentences, which seems to be at least, but my question is, I'm looking at the difference between A4 and A3 claims. A3 seems to say pretty explicitly you have to find people of different races who got less penalty. Am I correct that A4 does not say that? A4 just says other people who got less penalty. It says nothing about race in the narrative prong. Am I correct? Why is that the case? And should we change A3 to match A4?
I'm not following, because I understand A4, what am I trying to say? A4A is based on race of defendant, and then A4B is based on race of victim.
Correct. I'm not talking about that. What I'm talking about is that if you're trying to prove that you got a different charge than somebody of your race, then you have to prove two things. First, you have to prove the data, which we've been talking about. I'm going to wish that away. You also separately need to say you have to provide examples of people of different races who got less sentences. That's, if I'm correct, A3. A4 is about length of sentence, not charging. And under A4, you do not need to say other people of other races about
No,
lesser sentences.
no, you do. You do.
We-
I'm looking at it right now.
Yeah, I don't read it that way. It looks they
There's two prongs.
A longer or more severe sentence was more frequently imposed on people that share the defendant's race.
Read the prior, read the first clause.
That's what I'm reading. 4A.
Sorry, let me get to it.
Similarly situated, yeah,
Yes, similarly situated piece.
on people, yeah, oh, sure. I guess I'm with Lisa. I'm not really understanding.
I'm sorry, I don't have it pulled up. Give me half a second.
I read them as analogous in terms of the proof that's required. It seems to me like these are all similarly situated, meaning statistical disparities being demonstrated based on race, ethnicity, or national origin. One regarding conviction, another regarding sentencing of comparing people of your same race, and then sentencing compared with victims of the same race or different races.
Because this is important, I would like to just take a second to pull it up. And if you bear with me.
This is the first for us. This is like a Who Wants to Be a Millionaire, use a lifeline kind of situation.
I'm looking at.
I read them as the same. As
Let's look at A4, excuse me, A3 for a second. First clause. Defendant is charged or convicted with a more serious offense than defendants of other races, ethnicities who have engaged in similar conduct. Okay, we can stop right there. Compare that to the beginning of.
But I don't think you should stop there because it says and similarly situated.
Right, and similarly situated or more frequently obtained. Correct. I'm separating these out into two clauses. I'm with you, Priscilla. But look at the first clause of A4. A longer sentence was imposed on defendant than was imposed on other similarly situated individuals convicted of the same offense. That's different. The and part, the second prong that you just identified, Priscilla, is the same. Meaning, then you go to look for people with race, ethnicity. But at least the first prong, what I'm calling the narrative prong of A4, does not call into question the person's race. And I'm wondering why A3 and A4 are drafted differently when they're ostensibly trying to get to the same thing.
I guess
I guarantee you it was just random amendments.
Yeah, and also I don't read it the same way.
I think they're intended to be the same. I could be wrong, but I think that there was.
Also, just on Mary's point, but also goes on, the statement is and. I mean, the language says and there, and then it connects to defendant's race, ethnicity, or national origin, then on other defendants. So reading it in totality, I don't see them as two separate clauses, I guess is.
Well, my understanding is courts have treated them as separate clauses. First, you need to find narratives of certain examples, and then you have to provide the statistical analysis. Under the A3, it clearly says you have to find specific examples of people of different races and origins, and then provide the statistical analysis. A4 does not do that. And I agree, Mary, that this might just be lazy draftsmanship, but it is the law. Lisa.
Yeah, I haven't thought about it that way, but I am open to anything that gets rid of this idea that there's supposed to be a narrative, because I strongly believe if you look at the legislative history of this bill, which I spell out in an article that I published recently, that was never the intention. So the idea is you can have qualitative evidence, you can have quantitative evidence, you can have some measure of both if you happen to have that in your case, but it was never intended that you somehow always had to have both. So if changing A3 to read the similarly to A4 works in getting rid of that, I'm all for it.
Judge Cousins, I see you looking, I'm hoping you're looking at the statute. Do you read A3 and A4 differently?
I didn't. I read them the same.
Even now after looking at it.
Well, I don't know. I'm processing what you've raised, which is a fresh look at that I have not seen before, and I need time to process that. But I originally basically interpreted them the same in general application.
I think we all did, and as Mary said, I think even the legislature may have. However,
the words are different.
Yeah,
the words are different. I will give you that.
And not to be too professorial about it, when the legislature uses different words, they mean different things. Okay, I'll let everybody chew on that. It's one of the reasons why we are pursuing, and I think that the sentence length issues may be easier to litigate than the charging disparity issues under A3. We've gone on for way too long, or way long period of time. I've been thinking a lot about it. Obviously, everybody on this call have been thinking a lot about it. We really do hope to get some recommendations to make this more workable. Please keep your recommendations coming. Specific recommendations for fixes are always quite helpful. Thank you all. I'd like to say no good deed goes unpunished. We will certainly be back in touch with you. If you have reasons to reach out to me or staff, please do not hesitate. Thank you very much. Tom, before we let everybody go, do we want to talk about, should we break? How do members feel about, do we want to break for lunch or continue our conversation about RJA while it's fresh on mind?
Break for lunch.
Okay, to the panelists.
Thank you.
Goodbye. We're going to break for lunch, and then let me preview what we're going to do after lunch. Immediately following lunch, I would like to have our committee conversation about recommendations that we want staff to continue to develop. We're not voting on any recommendations. We're not making any recommendations. We're just trying to refine what our recommendations might be come November. That will be step one. Then we will close our conversation about RJA for today and move on to some new business, which is crime statistics, updates on refinements of issues from the past, and of course, public comment. Anything else that I'm missing, Tom, for after lunch?
No, that's it. Oh, and 6 more panels.
And 6 more panels.
No,
Stay
that's
comfortable.
it.
Thank you all. Is 45 minutes enough time for lunch for everybody? All right, so let's reconvene at, what does that make that? 1:20?
Do we need Steve back?
1:20.
1:20 close enough?
Yeah.
Have a good lunch. See everybody at 1:20. Thank you all for everybody in the audience. We'll be back.